wono so begina dakem na wodi na dance a ma pese mehwe Raf adanse die ne bi a wodi fi Ghana ebaye na yahwe nsama Raf ebekaye abra na oba bedi adanse die enti yahwe na
There is no appeal pending. Why is that? There is no appeal pending. Why is that? When Mr. Anas lost the matter in the High Court, he filed an appeal, and this was in 2023, somewhere in April, if my memory serves me right. And then he subsequently filed a process called certiorari in the Supreme Court, seeking to set aside the judgment of the High Court. So the Supreme Court, in a majority decision of 3-2, presided over by the leadership of the Chief Justice, said they dismissed Mr. Anas' decision. And an appeal in Ghana court can only be pending for 3 months. So there is no appeal pending so far as I'm concerned. The High Court judgment and the certiorari is the current decision in favor of the defendant.
And the findings of the lower judge were upheld?
Respectfully so. The lower judge had an additional responsibility because he's a court of appeal judge. So before he was promoted to the court of appeal, he was the presiding judge on the matter. So he did additional responsibility. So far as we are concerned, the judgment which has been affirmed because the certiorari was dismissed, by no means a person than the Chief Justice of the Republic of Ghana.
So the statements by the plaintiff that that case is on appeal are not correct?
It's not correct. The appeal has been struck out because he failed to pursue it. So there is no appeal.
And during the entire pendency of this matter since it started in 2018, did the plaintiff ever appeal?
No. He never appealed.
Not once?
He never appealed. And the picture that we had of him, he denied it. He denied it. So the question that the High Court judge had to answer in Accra was, if you are saying it is not you,
let's have a sidebar.
Na sidebar abba. Sidebar no de omukwa pa. Into obiara hwe se de awoyi na dance de ekona lawyer no judge sidebar. Na ya friend lawyer for me na akogina judge no nche na se wono ma den eye sidebar. Sidebar no ye secret consultations a omumienu na akodua no baba se no bebi a mehwe a osomesi we o kana sam kono enya de ebeboa nti judge bomode na hwe no nti ebu a oba say ladies and gentlemen, the objection sustained in nature say enya de a obetimi atua de o kana so move on to another. Ebu objection overruled. When it's overruled, it means that you can continue your case. Na enyoma bebre wo ha because of this na mensuma koye TV station and radio no me wo ho kwan say meye nkakra na approve evidences are afenuni na provide ye ebra na Anas wono a eti adakem na wono nso wedi na danse e ka de ato no na at a point no ka say expose a wo ye kura no even Dr. Mahmoud Bamia kura man $2 million kwesi yantechi se bema president $5 million Anas testify Dr. Bamia kura ni din wom and a lawyer no say Anas lawyer say here even your president took bribe $5 million your vice president $2 million enti Bamia nkrofo amubo se no Bamia kura de na ba America so no waje bribe $2 million ebeba na eba na mo de adanse ade na se ye nyoma bisa ed say o man no Ghana for me na ye asem na fidel it's just like a promise now MPP establishment ko tu gina nipa ba ko echi sa na de na koye wo mote ya obia etu ko gina ba ko echi ene ye celebrating kwe na Kennedy say susuam pass $15 million obetua enye no enkum no enye no hwe na moni bewu on that come ti say de yemu bi ekom de ye wo Ghana ye yam ye tim dance ya na ya twe kura ye de say journalism ene dwumedi ye wo Ghana no it is not enti based upon evidence by evidence I will be playing them is mistrialize it menso me ye a friend say me ye number 14 me de no be number 14
presumed damages $5 million.
Presumed damage $5 million.
Actual damages $5 million.
Actual damages $5 million.
And punitive damages $8 million.
And punitive damages $8 million, making $80 million.
We're done.
No, Judge.
Anas lawyer tell us we're done. Wama judge nimpanu ensio. No kase we done. Wama judge no nano ayade nano ensi kra. No see we done. No judge. Zavi de hono Anas mo show. Na de course no anti case no anya complete. Nti omanfo hu hono a womode ayewe no this is the problem. Na tiano baba eno
I'm requesting a mistrial. They current to consider punitive damages.
He is requesting for mistrial because the client considered punitive damages
In the initial, and you can't mold the verdict.
Initial going by no. Yes, munko hwehwe punitive damage numra. Sankrofo initial one na previously no omo no 80 million no omo de ahyemu dada. Inti breakdown evidence afeni ye ba hwehwe punitive damage no. Na bansa na mo makopre mo ho. Say mo de ahyemu dada. One na ma order me ma instructions say muntie na munde so. Adena mo makoye sa de we abrame. That is what Honorable Ken lawyer was challenging.
I'm once again requesting a remitted or based upon that, and a new trial should be granted based upon that response, Judge. They were not considered. They were outside of your. I'm just making a record, Judge, now if I could. Those are outside your instructions. They were required to follow your instructions.
You see? I say you are not allowed to move this or to enter because they work outside your instructions. They work outside, and the lawyer was emphatic on what he was saying.
Didn't follow your instructions.
They didn't follow your instructions.
Not permitted to mold that verdict.
You are not permitted to move that verdict
Because that's not form. A judge can only mold form. For instance,
a judge can only move form, but you are not permitted to. And the judge, we know, okay. So what is your request? But before then, Anas lawyer may interrupt the answer.
Since there's a lien, and you can mold the lien if the parties agree that you could pre-tax versus post-tax income. The judge is permitted to mold the verdict based upon the specific evidence that was presented. You are not allowed to mold that verdict. That's a remitter. There should be a new trial granted, and unfortunately, they did their job, and we should send them home.
Judge,
And then Anas lawyer no bemu abeka ne de no se judge. We grad in kay curable. I won't say on my mistake there nanso. Ogidi say nke we there wow do discretion aye hu bibia ntie. Asama ye gina jurifo eso ajaji na say mistake aba we say a judge no in the civil court no you can't. Mistake is a mistake. That calls for a retrial. But when they
basically, my thought is on their form, which is what was submitted to the court. It did state that it was presumed damages. On that basis, I believe that the instruction that Your Honor should send back was that the punitive damages and the actual damages were not included in.
So even in this case, lawyer Nanka Sakurano initially one tiase. This is how it is. Because I presume that nature said no him say initial instructions on the man or moment. Maybe a son as a second, but I feel no able to say error number
In that judgment.
I'd like to see the law, Judge. I think Your Honor was more than equipped than either of us to understand that when the jury sends that back and they haven't followed your instructions, and you can't send them back to re-deliberate.
You can't send them back to re-deliberate on the issue. The lawyer is so tough. Huh? I understand. And I feel that one son one back some go re-deliberate. And it's not this charge woman.
Had they had that question during deliberations, you could have given an instruction, a curative instruction.